My name is Nakato Michelle from St.Noa Girls Secondary School. I've come with Nega Louise Caroline, Nambi Florence, and Maria Framenchas.
Artificial intelligence generated works should be eligible for copyright protection. We are affirming this resolution and we are going against Seeta High School, Mbalala. We as Team Affirmative, we expect a win.
Hello, my name is Sacha Jemima Praise and I'm from Seeta High School, Mbalala campus, and my teammates are Raj Vivian, Nafula Martha, and Kibra Jonathan.
Tonight, we are negating the resolution that states that artificial intelligence generated works should be eligible for copyright protection against St.Noa Girls Secondary School. And for tonight's resolution, we really expect to win the resolution today because we have fully prepared.
House rules. Each speaker has 5 minutes. The first and last minutes are protected. The judge will ring a bell to signal the protected time. The bell will ring continuously after 5 minutes.
The panel of jury, the two antagonistic bodies, and the August House. This House believes that artificial intelligence generated works should be eligible for copyright protection. Candles flicker. Truth does not need light. Artificial intelligence generated works refer to the created content like text, images, or music produced by autonomously by artificial intelligence with minimal or no human intervention. Works like digital illustrations, paintings, animations, and clips. In this context, being eligible means meeting the legal criteria or requirements to qualify for something, or in this case, we want to assure you that artificial intelligence generated works are eligible for copyright protection. Copyright protection is the legal mechanism that gives the creator or the legal owner of an original work that gives the legal owner exclusive rights to produce the work, to create derivative works or distribute copies. We therefore advocate for this because of the current state of the AI of the artificial generated works, whereby there is an increasing prevalence of artificial intelligence generated works. Artificial intelligence works, according to the current reports, that the generative artificial intelligence is becoming a dominant force in online content creation, which experts predicting that 90% of online content could be AI-generated content by 2025. The influencer marketing survey found out that 67.1% of the influencers disclosed their use of artificial programs to their followers. For example, the US Corporate Office has clarified that it will only register works containing human contribution that meets threshold requirements. A 2024 survey of US data on privacy and artificial intelligence leaders found out that a whopping 84% of supports updating corporate law, which means that if we are to update the corporate law, we are able to make the artificial intelligence generated works eligible for corporate protection. Here at Team Affirmers, we come up with a work plan to ensure that artificial intelligence generated works are cooperated. The purpose of this work plan is to acknowledge rapid innovation in generative artificial intelligence and clarify need for legal frameworks becoming a balancing human creativity and originality, legal and ethical status. Step number 1, conducting comparative analysis and exercising corporate laws for about 1 month under the National Intellectual Property Office. What we mean is the artificial intelligence generated works have been produced, but what you're advocating for is that they are made eligible for the corporate protection. Many people have come up with a lot of designs using the AI, but their different copies are being produced. So what we are saying is we want a certain group of people that has done this thing to come up with the right authority so that they distribute their copies on their own, not other people that are even not concerned with that thing to come up and also distribute the same copies. Meaning that what we advocate for right now is that artificial intelligence generated works are given the right to corporate protection. Step number 2, identifying and consulting by stakeholders or artificial intelligence developers for about 1 month to 2 months under the Ministry of Innovation, Culture and Creative Industries department. Step 3, making a proposal based on a feedback to submit to the Parliament in about 6 months with the help of Interministerial Task Force on Intelligence Interaction Policy, Ministry of Justice, and Parliamentary Legal Council. Panel, the house that wins this debate will be the one that will fulfill the characterization of artificial intelligence generated works. Artificial intelligence generated works are characterized as machine generating. I beg to rest my case.
The topic of discussion tonight is artificial intelligence generated works should be eligible for copyright protection. Now I'll start with rebuttals. They come and tell us their definition of what artificial intelligence generated works are. These are works with minimal or low human intervention. Now, when we look at the criteria for a work to then qualify for a copyright, if it's an AI generated work, there should be substantial human intervention at the end of the day, and there should be human authorship, and also we see that there should be fixation and originality of work. Them excluding this kind of metrics then just kills their whole case. However, they come and give us a work plan. Now, what does this work plan show? This work plan just entirely shows that the works are not eligible. This is something they are trying to front for, but well, we will take the context of the debate being a value of judgment debate, and we'll take them at their best. They also tell us that, you know what, there is no human contribution, but we tell you that the only reason why they have side of the house is then going to face very many legality issues is that we are unaware of who then we compensate, and then they do not come and talk about and enlighten us about what the legal framework then would entail from their side of the house. When we look at cases, for example, the UK, where there is more permissiveness and plagiarism actually coming up because of actually a copyright then adjustment in the law, then it becomes bad because other countries then fear to kind of implement this. But we tell you that artificial intelligence are technological systems that perform a variety of functions, study human behavior, analyze that, and have ability of actually offering sufficient responses to questions asked to them. We tell you characteristics of AI are 1, it has the ability to learn using different sources. Why is this bad to their case? We tell them that notice that they also learn from other sources, ingesting material of other workers without then notifying them about copyrights and without compensation. We also tell you that it also doesn't have its own sources of information. That's why it becomes bad. We tell you that users, it works on an algorithm and user preferences. What does this mean? Is that users get the same or similar information, which then derives them to the same product. That's why we tell you that at the end of the day, copyright would not make sense, yet these AI systems themselves are taking information from non-copyrighted sources at the end of the day. That becomes bad. We tell you that what are AI-generated works? AI-generated works are works driven by AI. We tell you that on characterization, that AI-generated works are majorly ideas or then prototypes. We tell you that prototypes are not works that are liable for copyright. Works that are liable for copyright are works that are products. That's why we tell you that there needs to be a physical medium or a tangible information that then actually qualifies for what copyright then entails. We tell you that too. On eligibility, we tell you that it's a state of having the right to do or obtain something through satisfaction of the appropriate conditions. That's why we tell you that at the end of the day, where the conditions are originality, where originality is the ability to think independently and creatively. Now let us highlight independently in this case. Now where a person is unable to then actually think independently, then that is not originality. We think them underlining originality as just ideas then is not tonight's debate. We tell you that on matters of human authorship, where a person is able to actually come up with human authorship is that you're able to sit down and come up with something on your own. We tell you that at the end of the day, copyright also entails things like fixation. Now, what is fixation? Fixation is a requirement of copyright law for a work to be recorded in some permanent form or give rise to protection rather than simply existing as an idea. But we tell you that copyright is a type of intellectual property that gives its owner the executive legal right to copy, distribute, adapt, and display and perform their creative art. We tell you that, notice, the big question in tonight's debate lies on the legality that lies from their side of the house. We tell them if they can answer who can be compensated, can give us the effect and how that is actually going to be good for their side, then they would win tonight's debate. We tell you that on effect, what happens when we give copyright laws to these kinds of things? We tell that there is a rise, according to the US Federal Court, over 30% there's a 30% increase in the cases related to AI complex copyright issues. We tell you that AI can't have human authorship even with idea prompts. We tell you AI can follow instructions and produce content that adheres to a specific structure, but the issue comes in on the repetitive language and predictable sentence patterns, but human authorship tends to vary from sentence to sentence. The kind of human natural content that is engraved in the content then creates originality and creates human authorship. We tell you at the end of the day, when you make a song using AI, we have a number of people. For example, we have 2 people then making that kind of thing. We think necessarily the idea is repeatedly interpreted. This dilutes quality.
This is the High School Crossfire. We'll be back in a minute. This is the High School Crossfire. Welcome back.
This house believes that artificial intelligence generated works should be eligible for copyright protection. As our status quo states, state that is necessitating for the bringing up of this resolution is increasing prevalence of AI-generated works without considering the developers. According to Statista reports, that generative artificial intelligence is becoming a dominant force in online content creation, with experts predicting that 90% of online content could be could be artificial intelligence generated by 2025. The user marketing survey found out that 67% of influencers disclose their use of artificial intelligence programs to their followers. This means that most of our influencers, let me say like the native influencers and our international influencers, use artificial intelligence, meaning they are also generating works using it. So, as I've come to rebut, and Negeta one came and said that our Farmer one did not say that if the copyright law is updated. But well, our Farmer one came and said that if the copyright law is updated, that is when we are able to make artificial intelligence generated works. And the artificial intelligence compensates for the artificial intelligence developers. As I come to my beginning of the qualitative argument, a 2024 survey of US data found out that whopping 84% support data copyright law against artificial intelligence misuse, with 81% also endorsing compensation for whose work powers artificial intelligence models. As we team affirmative, come up with these qualitative arguments to assure the August House that we are well versed with the policy we want to implement. Firstly, this policy is making artificial intelligence generated works to have copyright protection, which promotes economic incentives and innovation. Copyright law has traditionally been used as a tool of incentive creators by granting the exclusive rights to their works. And if the artificial intelligence generated works can be copyrighted, it could foster further development and innovation in artificial intelligence technology, encouraging more creators, businesses, and individuals to utilize artificial intelligence in creative industries like music, visual arts, and literature. This means that most users or individuals or influencers will use more of the artificial intelligence, which they will use their knowledge to generate their works. Secondly is market value. AI-generated works have commercial value, and copyright protection would help them maintain that value. Without copyright, works produced by artificial intelligence might be easily copied, undermining the economic potential of artificial intelligence-generated works like art, literature, and music. Meaning, the artificial intelligence works should be given value. They should be copyrighted. They should be given copyright protection, so that they should give value to the to the artificial intelligence developers. I rest my case.
Panel, allow me dive back into rebuttals. So we're going to start with the affirmative one. Now, the affirmative one comes and defines their case and tells us that, you know what, AI-developed works are entirely either generated by AI or they have minimal human intervention. Now, that's where affirmative team starts to fail from, because if we are to give copyright, the criteria for giving copyright, it says that there has to be authentic human authorship. Now, if their kind of definition of AI-generated works comes with minimal work, then that means they start failing from there. Now, they come and talk about the increasing AI developers, right? Now, we come and show you that at the end of the day, the AI users are the ones who are generating the works they are talking about. But then now for them, they come and talk about AI developers. AI developers are people who are creating the AI programs, like AI, Open AI, things like ChatGPT. So now for them, in their case, they want to compensate the AI developers. So if AI developers are creating the apps we are using to generate work, then why are you not compensating? In their case, they are not compensating the users who are creating the work, but they want to compensate the AI developers. Now, at the end of the day, they come and tell us that, you know what? In their case, they show us that in their kind of world, when they give copyright, they're going to increase market value. But now these are some of the reasons as to why this is one of the reasons as to why we are refusing copyright. Now we come and tell you, why are we not agreeing with giving copyright to AI-generated work? In the first place, AI-generated works fail on criteria for applying for copyright protection. Now, it starts with originality. Originality, as explained by my first affirmative, shows that it has to come from an owner, the human authorship. But now with AI, it's getting data from different kind of sources. So that gives it no right to claim that it's its original work. Now we come and tell you that it has fixation. To give copyright, there has to be fixation. What is fixation? Fixation is where there is a tangible medium for it. Now that's kind of work that is recorded, that is written down, but at the end of the day, that kind of work is not in AI. AI-generated works are usually prototype and ideas. So how are we giving copyright to that? Now, we come and show you that, you know what, to our world, if AI is given at the end of the day, we are going to have flood of mass product content creation. Now, what is this? What is this? Now, this is where every single small person is creating kind of content and they're copyrighting it. At the end of the day, if this we are looking at markets where people's ideas are being displayed out there, people are getting inspiration from such ideas. Now, this is the kind of creativity we are looking at. People are getting ideas from these kinds of markets and they are creating, we are looking at some kind of, they will take it. We're looking at some kind of creativity. But now, if there is copyright to every kind of idea like this, then we are limiting sources of inspiration to kind of creativity. And at the end of the day, we are affecting the creativity community, because if we are limiting inspiration to such kinds of work, then I don't know where we're running to this kind of economy. Now, we come and tell you, you know what? At the end of the day, we are going to have increased lawsuits. Now, looking at the US lawsuits, according to the US Federal Code, there has been increase in court about related copyright issues. Now we are looking at this kind of where they do not give us who are we compensating at the end of the day. Are we compensating AI? Are we compensating the user? Now in this motion, if Team Affirmative cannot come and prove to us beyond the reasonable doubt how originality that qualifies for criteria of AI comes to their side, and who they are going to compensate at the end of the day, or how this is going to help public domain in society, then Team Affirmative has no case to prove to us. Now, Team Affirmative will come and build up a case of where there is human input at the end of the day, but to what extent does a human have control over the product AI is giving? Then, at the end of the day, we are looking at a world where it looks like in a world where you get somebody, put them in the middle of the road and tell them, walk to that building. How the person gets to that building is entirely their effort. All you did is show them the way. Now that's what humans do. They input little data to the AI, then AI creates all the work. And from there, AI-generated work start to fail on what criteria is given for copyright rules.
This is the High School Crossfire. We'll be back in a minute. This is the High School Crossfire. Welcome back.
Panel, at this moment, ideas are the battlefield and opponents' argument is stepping in barefoot. It's not about volume, but about the echoes when you are done speaking. Resolved. This House believes that artificial intelligence-generated works should be eligible for copyright protection. Panel, when you look at the team negative, they're not really aware of this resolution. They didn't make enough research, because when they come and tell us that, we should make them aware that these artificial generated works should have human authorship. This is their burden, not our burden. Even Negeta came here and told us that for copyright to be given to artificial generated content, it should have human authorship. But what our farmers have stated is the work plan reviewing the copyright law to grant copyright to non-human authorship. When we look at the current state, we are seeing that the increasing prevalence of the artificial intelligence generated works, this is forcing us to bring this policy into place. When you look at our sources, it is showing us that our recent entrance of paradise, that was an AI-generated image, it was refused to be given copyright because it had no human intervention. We as Team Affirmative, we are the lawyers of artificial intelligence generated work. We have to assure the August House that the AI generated works should be given the copyright protection. On the other hand, they are telling us that we don't have a legal framework. Our legal framework is that Team Negative should get to know that we are giving a work plan as reviewing the copyright law to grant copyright to non-human authorship. You get? Because when you look at the AI really, it just means machine content. When you look at the characterization, machine content, creativity and originality, legal and ethical status. When you add in the human intervention, you are really telling us that it's not creativity and originality. We as Team Affirmative want to assure the Team Negative that they are not really well versed. They didn't make enough research. Because even they are coming and telling us that there should be content change in AI-generated works. When you look at AI-generated work, it's not telling us human-generated work, but artificial intelligence-generated work. You should get to know that we as the lawyers of the artificial-generated works are here to bring in the policy for the AI-generated works to be given copyright protection. According to the Statista reports, the generative artificial intelligence is becoming a dominant force on the online content. So, when we give in the copyright protection, we shall ensure that this AI-generated content is given out at a minimum volume. When something is overused, it's really not valued a lot. When we give in the copyright protection to the AI-generated works, we shall have the incentives. The Team Negative is not really bringing out their points. They are not even giving us their point, the alternative point. It's instead they are basing on our argument to bring out something to themselves. They are just bothered about the volume, but not the echoes out of their volume. So the Team Affirmative, we therefore say that copyright protection should be given to the AI-generated content to give economic incentives and innovation, recognition of human effort behind the AI, aligning with human creativity. On the other hand, authenticity of human intervention is not a big deal in this resolution. It's not a big deal in our policy. Because if you bring in the human intervention, you've really killed the resolution of that day. For today, we are basing on artificial intelligence generated works, not human generated works. I rest my case.
I'd like to begin my speech in 3, 2, 1. But no, I think something that is misunderstood by Side Affirmative majorly lies on the metrics that we present about in today's debate. Notice that right from the first to the second speeches, we tell you that there are metrics upon which copyright is to be given, upon which an AI-generated work is to be eligible for copyright, right? One thing we tell you about is that there has to be a certain degree of authorship, right? There has to be originality in the product. Originality looks in the sense that there has to be a certain humane level of independence in terms of that work and creativity in terms of that work, right? And then thirdly, we tell you that at the end of the day, there needs to be fixation. It needs to be in terms of something that is not an idea or a prototype, but rather something that is in form of, let's say, something that's been written down or noted down. But no, I think the main reason as to why Team Affirmative fails to understand our side of the case is because, one, they don't understand that AI is more of a tool, right? At the end of the day, AI has got a certain degree upon which, or a certain way how it works, right? Right from the second speech, we tell you that, one, at a point in time whereby you simply implement, I'll take it later on. We tell you that at a certain point in time whereby you input an idea into AI, right? You give AI leeway to take one direction, to take another direction, or to take another direction. We believe that is not creativity and that is not independence. At the end of the day, that is not a metric upon which we can then say AI-generated work is really eligible for copyright protection. But no, I think one thing you're going to realize in our rebuttals, right? The major argument they have here is prevalence in AI work without recognition, right? One, we're going to provide to you this particular link. We're going to provide for you this particular response, right? We tell you that, okay, yes, it's okay to recognize people. However, what are you recognizing these people for? We tell you clearly that we're going to differ when you talk of people having AI-generated works in the context. Why? Because we believe AI-generated works don't really fit the metrics upon which something is to be granted copyright. Yes, we say copyright needs to be given, recognition needs to be granted, but at a point in time the metrics are not met, then we believe that particular work does not really deserve to be given a copyright. I think the second rebuttal that we're going to look at is when you look at the market value that they talk about. One, according to dikema.com, you realize that very many UK-based AI developers have really run away from the markets. Why? Because when you look at the monetary attachment and also the input of this law whereby they're now copyrighting the system, at the end of the day, it really disregards or it really sort of disfavors these particular entrepreneurs or these developers. That in essence is no way reflecting the monetary value that is going to be achieved on their side. So I think at the end of the day, our side is still really winning them on that particular argument, right? I'd like to take you.
Do you get the difference between artificial intelligence generated works and artificial intelligence assisted works?
Well, I think I'd like to continue with my speech because clearly that question doesn't really have much of a difference. I think artificial intelligence generated works and artificial intelligence assisted works are sort of the same thing. That's what we are talking about in today's debate. Pano, I'd like to continue. The reasons as to why we win today's particular debate. One, we show you that at the end of the day, one, it sort of seems illogic to seek for permission to, let's say, copyright your particular piece of work, and then at the end of the day, you don't want to seek for permission to ingest it. That comes out right from our first speeches, right? The reasons as to why they will stand a greater chance of losing today's debate is one, their model, first of all, is quite inefficient. It doesn't fit the metrics. Yes, we say that there needs to be recognition, but the principle of recognition cannot stand when at a point in time you don't really assist or you don't really in any way fit the metrics upon which something is to be given a copyright. And then lastly, we'll show you that on a copyright, if at all, yes, their side is to really come true, still, we realize that there going to be limited creativity. An example is the case I've already given you in Dikema.com, whereby entrepreneurs have really run away. The AI developers, the very people they are talking about. And at the end of the day, it's sort of a confusion still on their side because they're now taking the debate more into AI users, and into AI developers, and yet the debate is majorly lying on the AI developers, on the AI users and not the AI developers whom they're talking about. So I think at the end of the day, our side will really stand a greater chance in terms of winning them. I think with that, I'd like to rest my case. Thank you.
This is the High School Crossfire. We'll be back in a minute. This is the High School Crossfire. Welcome back.
Does AI have its own sources of information?
Pardon?
Does AI have its own sources of information?
Yes.
Does AI use other people's work for
No.
completion? Does AI compensate these people?
Pardon?
Does AI compensate these people that
No.
obtains this information from?
No, since it's a software.
Okay. Would AI still be effective without content?
Pardon?
Would AI still be effective without content?
Of course, it cannot get out
I
of
want short
context. It's
responses,
a
please.
software.
Does a user have complete control on the final product?
Yes.
Does AI produce final products or prototypes?
Yes. But it doesn't produce prototypes.
Short responses, please. Does eligibility require fulfillment of certain conditions?
Pardon?
Does eligibility require fulfillment of certain conditions?
No.
I beg your pardon?
Yes.
What exactly are these conditions?
Pardon?
What exactly are these conditions?
It requires to fulfill the AI characteristics, which are machine
Short
work.
responses, please.
You asked an open-ended question, so I had to explain.
Okay. Who are we compensating? Who are you guys compensating?
We are compensating the programmers and the developers.
Okay. Thank you so much. The range of questions that I've actually asked the first speaker of the affirmative side, and at the end of the day, I'm not getting what they actually understand. Now, Pano, I asked them, does AI have its own sources of information? And she said, yes. And AI, we all, as according to my first speaker, she clearly said that AI collects information from different websites and different sources of information and compiles it and presents it to a person. So at the end of the day, her answer doesn't make sense. What are you trying to say at the end of the day? We're trying to say that AI actually, if we are to give copyright law protection to AI-generated works, at the end of the day, the efficiency of AI will be what? Reduced. Why? Because in AI, to actually give you any work, it has to access different websites. And if those different websites with the information they have are copyrighted, at the end of the day, AI will not be able to provide you with anything. At the end of the day, it's still meeting the criteria for copyright protection. I also asked them, does a user have complete control of the final product? And she said, yes. At the end of the day, we're talking about AI-generated works. A person inputs in their work. For example, if I want to make a book, I tell AI I want a book. AI will make its own chapters, its own wording, its own every single thing. At the end of the day, me as a person, I do not have control over that work. At the end of the day, it doesn't meet the criteria for eligibility for copyright law protection. Because at the end of the day, there has to be human authorship. There has to be originality. You have to prove that the work that's actually being produced belongs to you, that the wording, the chapters and everything. So at the end of the day, it does not actually what? It does not fit the criteria for what copyright law protection. I also asked her, does AI produce final products or what? Prototypes. And she said, yes. Now, Pano, according to a characterization that was given by my first speaker, AI actually only produces prototypes and ideas. Why? You ask AI to make for your book, to just give you a prototype of the book, and at the end of the day, that's not what copyright law protection. It does not meet the criteria for copyright law protection, because at the end of the day, copyright law protection is given to things that fit.
Do you know copyright helps merchants to register and protect their AI-generated products, descriptions, or branding assets? Yes or no?
No.
Do you know someone's... Can you mine the output without focusing the input?
I beg your pardon?
Can you mine the output without focusing the input?
You have to focus on the input.
Correct. Do you believe that developers of the AI-generated works get to protect the unique AI-generated work when it's given copyright protection?
Yes.
Do you know that artificial intelligence-generated footage would allow licensing to streaming platforms and ensure creators to get paid?
No.
She doesn't know.
No.
Okay. Okay. Do you know that basing on the characteristics of artificial intelligence, it is not a prototype or an idea?
Depending on the characterization.
I asked for a yes or no.
No.
Do you know that artificial intelligence, it does not leak any other sources, but it does its work on its own since it's a software?
It actually leaks other
I
sources.
asked for a yes or no.
It actually leaks other sources.
I asked for yes or no. She doesn't know. Did you know that most influencers are telling the followers that they are actually using artificial intelligence programs to do their work?
That's only on your side.
Okay. Thank you. According to the questions I asked her, she clearly stated it that they are on our side, that since the influencers are breaking the secrets to their followers, that they actually use artificial intelligence generated work to get the followers. This clearly shows that the negators do not know what they are talking about as they are coming to the side of the affirmers to show us how the artificial intelligence generated work is important and needs to be given copyright protection. I continued and asked her whether she knows that artificial intelligence, according to the characteristics of artificial intelligence, it is not a prototype or an idea, and she said she did not know. And not forgetting to tell her that artificial intelligence generated work has characteristics of being machine generated content, authorship and attribution, creativity with technological progress. According to the questions I told her, she was showing that artificial intelligence generated work is like it's missing something, which is the copyright protection that we as Team Affirmative has come to show how it will gain it. I continued and asked her whether it is good for the developers to protect the artificial intelligence generated elements, the unique elements, and she said yes, it is good for them. But according to the speeches the fellow speakers are giving in the negator side, they are showing that it is not good, of which she is contradicting with their case. She continued and said that it is not good for the artificial intelligence generated footage to allow licensing to streaming platforms and ensure creators, yet they were claiming who is gaining from the copyright protection of the artificial intelligence, of which I would like to show her that since it is given copyright protection, that creators are being paid. We are appreciating someone rather than their house, which is coming and failing to show us who is going to gain and who is going to lose it out. I continued and asked her whether she knows that merchants are getting registered and protecting their work, and she said she doesn't know. I beg to rest my case.
Thank you for this debate. We shall delve into what you people debated now. The resolution today before us was whether we should have AI-generated works become eligible for copyright or not. Now, Team Affirmative was saying that they should. You gave your reasons. Team Negative, you said that we shouldn't, and you gave your reasons. Now, I would first like to debunk some of the issues. First of all, Team Affirmative. You know, Team Negative, sometimes there can be, you can use a word over and over again and define it in a certain way when it's not that. Now, when you were discussing your point of argument of fixation stage, yeah, it is a very good argument. However, now when you delve back into the word prototype, you kept on using the word prototype, prototype, prototype. Now, the word prototype does not, because you mentioned that it makes it intangible and it's merely an idea. Whereas the word prototype, it is the first thing they put out of a product, and it is not an idea. So we do understand, because you kept on referring to your references were understood, however, they were clothed in a wrong word. You get that? But we shall take it up because team affirmative does not point it out, though it's a correction. Now, moving on, we have what? We have a team affirmative that comes up and you define your keywords the way you define them. Now, by now you both know, both teams, you know that there are generative works and then there are automated works. Now, you defined the whatever, or because you do not set a perimeter. So we'll go with your definition of words, the way you define them and how you use them. You come up and you tell us about generative works made by what? By AI. Now, if you're looking at generative works are works made by AI whereby I input data into my AI the same way your ChatGPT has data from all other sources or search engines, from all other search engines. So that is the data that has been input into it. And you always ask or request for what? For a reply. Notebook, KLM, ChatGPT, all these AI other things. You input data, then it gives you a result. Now, that is the type of AI that you were all discussing about. Team negative comes up and states its two reasons as to why. Because it does not fit into the criteria of what? Of AI. Of what? Of copyrightable work. You give us originality and then you give us your fixation stage, which is, we are going to take it up as material form. Now, team negative, you come up, I'm going to try and summarize, you come up and you tell us that at the end of the day, you are not in your third speaker's speech, as much as you take this up as a policy debate. It is in your third speaker's speech that you come up and you tell us that, you know what, for us, we are not going to consider human intervention as what? As a criteria to copyright AI works. Now, some of the questions that were asked by Team Negative were, what legal framework are you going to use? You did not answer to us what legal framework you're going to use. Second of all, they ask you, who are you going to pay to this work or the economic value that is made out of the AI? Now, one of you comes up and tells us, I think it is the second speaker, they come up and they tell us that it is the AI developers that are going to be given this money. Now, the question that is posed by Team Negative is, I developed ChatGPT. At the end of the day, someone else is going to use ChatGPT information to make something out of what? Out of that AI. Whereas they did not interact with me, the developer. So why is it that the developer of the app that I have used to generate various works going to benefit, and me, the user who used ChatGPT, not going to benefit? Now, let's take it up that at your best case that yes, you've won the argument of what? Of originality. They come up and they tell you once again that when you're looking at the way AI makes up its work, at the end of the day, it is going to get information from various sources. Now, originality does not mean that I am the first person to think about making this shirt. No, originality merely means that there was a bit of human effort and knowledge that made this work. Now, personally for me, AI work the way you explain it ends up becoming probably a derivative work of another person's work that was made by what? By AI. Now, to summarize it all, very key points as to originality and what? And fixation were not given an answer to. Now, getting those in balance with market value and relevance of AI, it is not really a fair balance to the max. I gave both of you 15 for style, 25, 28 for strategy, 24, 24 for content, totaling to 64 for team affirmative and 67 for team negative.
All right. Thank you for a fairly good round of debates. I think this is a resolution that has not been exploited by both teams. One, there was no reason for us to have plans, policies, whatsoever to the affirmative team. That means you wasted a lot of time debating a policy that was not necessary at all. And again, this question already knows the status of copyright protection. We already know that anything to be copyrighted, it must be original, it must be authentic, it must be reduced into material form, which negative team calls fixation, and such work should be protected. Question is, should artificial intelligence generated work be protected? At that point, I expect the affirmative team to recognize that there is a problem with the status quo in how copyright works. It does not protect human artificial intelligence generated work. Now, you should make that clear to the panel and to your opponents that you're debating a world where it is possible to protect artificial intelligence works. Your entire debate is, at the end of the day, is it important to protect AI-generated works, which did not come out in this debate. That is why we tell you that you told us so much about how and so little about why. Why should we protect AI-generated work, apart from, the logic that much of the content belongs to AI? So if we protect it, so what? What will be the difference? That's the question. Who do we pay? You get it? If you are making some connection that if we protect AI works, maybe the AI company will be paid, and the AI company will generate money, which goes to the developer, and the developer will have an incentive of making more. That gives us a rationale of protecting AI works. But otherwise, if they tell us whom do we pay, and you just say the developer, you have not exploited the reason of why should we protect AI-generated works. So in today's debate, the affirmative team, I felt that you slacked in exploiting why AI works should be protected. Number two, I felt that you were in between positions to choose which side you wanted to support. At some point, it looked like in your debate, AI-generated works are those entirely built by artificial intelligence on its own. At another point, when a contrary view comes in of human intervention, you seem to be two-footed to choose either that this AI is entirely independent or that some works are attributed to its creator, which then begs the question, is it an entirely work generated by artificial intelligence on its own, or is there some human contribution? However, I must commend that you are able to look at, and for me that's the winning point, the fact that you could look at the fact that AI as it is designed simply looks at developed works, developed ideas to create its own work, even when humans have not interfered with it. As such, it begs the question, can that work then be authentic? Can it be original? Can AI then be an author? If it has read an article and another to come up with a certain conclusion, isn't it just producing from what has already been made? And that question, for me, is not answered by the negative team, whereas your biggest role is to prove. You have a fundamental secondary role to rebut. Did not answer that question, and that is why the negative team edged off the affirmative team. I gave 62 in total, the affirmative team, and 65 in total to the negative team. I differed in strategy where I gave 22 and 25 in that regard. Thank you very much.
Thank you. A lot has already been said. I will not repeat. Just something to tell you, both sides. One, to start with team affirmative. The only way you can rebut an existing legislation for provision of something is by advocating why there needs to be an amendment. So for example, when team negative restricts you to the fact that you say, by virtue that the current position of the law to do with copyright is that there has to be originality, then it is not just enough for it to say that now for us we are going to do this. No, the only thing you need to do is now tell them why does now there need to be an amendment that does not favor originality. So the biggest argument you had to tell them today is, despite the fact that that is what the law provides, the law is subject to the changes. That is why we are having amendments. Because for them, their biggest alternative was telling you that, no, if you look at whatever you're talking about, this is what the provision is talking about. So that's why you see for them, they're talking about that. You see corporate is dealing with material form, corporate is dealing with originality. So that's why now they keep on asking you that if now we are having AI that is generating information from different sources, then how does that amount to originality? So now the biggest rebuttal you could ever come and tell them such is that you see the law, despite that fact, that's what you're talking about, that's the provision of the law, but the provision or the law is subject to the changes. So despite the fact that that is what you're talking about, for us, this is what we're advocating for, and that's why we want to do A, B, C, D. So now for when you keep on coming, you still get under their trap. Okay, now do you now rule out, because the truth of the matter is, in the current status quo, the current legal provisions of copyright, you can never rule out the argument of originality, you can never rule out the argument of being reduced to material form. So now the only thing you have to tell them is, now why should there be an amendment that is not looking at originality? Why should there be an amendment that is not looking at the fact that you're reducing it to material form? That is the biggest argument you could ever have. Copyright goes to material form. Do you have an extensive argument that you could ever support for you to argue that now AI generated work should not be protected by the copyright? Besides what the law provides, what extensive do you have? Because on another day, what about if you're faced with an opponent that is able to come and qualify or to quash the biggest argument you have, that you say this is what the law provides and that's what we should do? What about you having an opponent that is able to rebut what you have? Are you now able to come and make a counter argument to whatever they are talking about? So that's why you say other judges are telling you that another, not just stick to the law. Yes, it's very right. That is what the law provides, and it was not a bad argument. But also another, they have an extensive that, yes, even if this is also what the law provides, go ahead and now justify to them that despite, okay, even putting the law said that that is what it's providing for, if we are now to go extensively, why shouldn't we make the AI-generated work to be subject to the copyright protection? The biggest argument or the biggest question that was to be answered today was not the how question. The biggest question that was meant to be answered was the why. So even if you are to make it policy or let it be value, then why? Why should there be protection? Why shouldn't there be protection? The marks: 16 for style, 26 for strategy, 28, 27 for content, 27, making a total of 69 for affirmative, 71 for negative. So it is a unanimous judgment of 3/3 that Team Negative takes it. Thank you so much.